Hi, I'm Dr. Jerry Lewis, and I'd like to welcome you to Topics of Interest. Today we're going to be talking with Tony Pelusi. Tony's an attorney, and he's going to be talking about the do's and don'ts of parent coordinating. Tony's practice is up in North Andover. However, he retired from doing straightforward legal work back in 2002. Since then, he's been spending most of his time doing coaching as well as parent coordinating. He's a member of MAGL as well as AFCC and is currently on the board of AFCC. So in just a moment, we're going to be talking with Tony.
What I'm about to share with you is my experiences in parenting coordination. One thing I've learned, there's no one way to do anything, right? There's many, many different approaches to accomplishing a task. So what I'm going to offer to you today is information that I hope you will find helpful and useful. But I'm going to advise you to synthesize it with your own practices and ultimately to let your experience guide you in how you do this, this challenging but very rewarding work of parenting coordination. I'm going to start off by identifying a bit of a paradox, that being what's very effective, proven to be very effective in my practice, is having a process, and at the same time being able to be flexible within the realm of that process. The approach that I use in parenting coordination is quite different than the approach I use with coaching or with my mediation practice. Primarily, I'm working with the same audience, but I notice that the intent of what the clients bring is different. In coaching and in mediation, it's a completely voluntary process where people are motivated and desirous of creating change. My experience in the parenting coordination world is that although there is a motivation to change, usually it's one party's desire to change the other, as opposed to doing the work that's necessary for themselves in order to have the relationship improve. I guess the best piece of information, the best piece of learning that has come to me in the parenting coordination work is to stay current with trainings. There's some great ones, as you know, by MAGL, by AFCC, MCLC, great groups out there that can offer us all kinds of information to help us improve our practice. The other thing that I have found to be very important is to have a consultation group. And in fact, we have one. It is scheduled for the second Friday of every month at noontime. And if there's any interest in joining it, it's a drop-in. There's no obligation. You can email me, and the information will be provided at the website on how to join that. And everyone is welcome to do that. Lastly, by way of introduction, the most important thing that I've found that is necessary for me is to make sure that I take care of myself. And that can come in the form of walking, meditating, going on retreats, but doing something to stay centered, because the work is very demanding. We place ourselves in the middle of conflict, and it's high conflict, and it's very emotional and personal conflict because it involves the children of our clients. So I strongly urge you to do whatever it is that is your practice to help you remain centered. Those of us that practice parenting coordination are now governed by Standing Order 117, and that sets out the process of appointment. We're not going to talk about that so much today, but I think it is important, in order to have a strong foundation in the work, that the PC at least consult with counsel and the clients before the engagement begins, so that there's a shared understanding of what this process is going to be. Some of the most difficult times I've had is when a client says to me, well, that's not what it was explained to me. And my general response is, well, if you had looked at the service agreements and policies and guidelines that I sent to you before we started the engagement and read them, you would know that this is the process that we're going to use. So that's probably the best starting point. Establish a clear set of understandings on what are going to be the terms of engagement. I start off from the business perspective of saying, okay, I want a retainer, and I want to have a clear understanding of how much the cap is going to be, and when the retainer is going to need to be to be replenished. And honestly, what happens if the retainer isn't replenished? In my practice, and I'm not shilling for our family wizard, but in my practice, our family wizard is an absolute must. And I do that as much for me as I do for the clients. It provides me with one safe space where I can go and look at anything that I need to regarding my clients, and it segregates that from the rest of my life and the work that I have. I'll talk a little bit more about that in a bit. One of the things that I've noticed is that it's very common for one party or the other, particularly after a decision has been made that is not to their liking, to kind of withdraw or maybe want to boycott the process. Sorry, I can't make that call, or I'm not going to participate in this discussion. In order to make sure that that is not an impediment to doing the work, I make it very clear in my engagement material that you can, if you choose not to show up, that doesn't mean that we're not going to deal with the issue. So there's no boycotting of the process. And I'm very clear about the process that I use as far as communication. Like I said, everything is in our family wizard. I introduce the clients to Marshall Rosenberg's work on nonviolent communication, Bill Eddy's work on BIF, and Bill Eddy's work on So What's Your Proposal. And although there's a learning curve in getting clients to understand how to use these processes effectively, I find that once they are used to following them, the ability for them to actually start to learn to resolve their own problems increases. And that's ultimately what I would like. My job is to put myself out of business. So like I said, there's a set of protocols called the service agreement, policies and guidelines, and a communication protocol. And all of these are freely available on my website. If you take a look at them, you're welcome to use them as I have developed them over time. I suppose the biggest challenge at the beginning, where there has been no trust established, is please sign this release. And why do you need a release? And who's this a release for? I use a blank release form, and I ask clients to sign it up front with the assurance that I would never speak to a third party unless they know who I'm going to be speaking with and they give me permission. And even with that, I've had resistance from clients in signing releases. My experience in my first PC case was to succumb to the desire of the clients and not have them sign a release. Fast forward about 9 months, we get to a point where I need a release. It took 6 weeks with counsel to get them to agree on the terms of a release that they would let me have. So my position right now is pretty much clear. If you're not going to sign the release up front, then I'm not going to work with you. And in all honesty, that is one of the terms of the engagement that's spelled out in the service agreements. I'm not going to go into some of the business practices. I'm sure you have your own about accounting and what you're going to do as far as when billing gets behind. But another key aspect of the PC work is that nettlesome language that gives us the authority to reallocate fees. Normally it's 50-50, although I've got a couple of cases now where one party is paying and there still is binding authority. But in those cases where it's 50-50, I try to make it clear up front that just because I'm going to be speaking with one person or directing an email exchange with one person, that doesn't mean that only that person pays. In my service agreement, there's some very specific criteria that have to get met in order for me to reallocate costs. I do it rarely, and I often have to remind my clients of what those criteria are when they ask me to do that. The other thing that I do in my practice, and it is yet to be tested, is I make it very clear I am not going to come to court and testify. I am trained as a GAL, but I don't testify any longer. I'm an attorney. I've been on the witness stand. I've been questioned. I'm done with those days. So I have built into my agreements some protections that make it very difficult to get me to court and testify. And it has yet to, these positions have yet to be challenged, and we'll see what happens if the day should ever come. But a protection that I build in for the benefit of the clients in the process is in the service agreement, both parties agree that anything that is in our family wizard is admissible in court without objection by the other party, except for if they have an attorney, any attorney-client privileged communications. And I find that that's a helpful substitute. The way I do the practice, everything concerning a particular decision is going to be contained in our family wizard in the thread, and I'll talk about that in a little bit. I start off by giving my clients a policies and guidelines statement. It sets out my philosophy. It sets out the goals that I would like to help them achieve. And of course, I ask them for their input if there's any additional goals that they would like to bring. But primarily, I want to help them to de-escalate the conflict and contain the conflict. Separate the conflict from the children. I started off thinking that, especially as an attorney, I was going to help them remove their conflict. Well, I was disabused of that fantasy pretty quickly. And so, as I said, we want to isolate the conflict from the children from the conflict. One tool that I found to be very effective is to work with the clients in the first meeting, in my initial joint session. And I should back up a second. I generally have an initial session individually with one parent, individually with the other parent, and then we have a joint session. In between the two sessions, there's some homework that I ask them to do. They'll go to look at some websites, some videos on websites. Split, how the brain is developed, ACEs. There's a movie called Tears. All of these are on my website if you want to see them. And I have them look at it, and when we get back together, I ask them to identify one piece of important learning that they picked up from those videos. And then, once they've each identified that learning, I ask them and invite them to adopt that as a commitment that they will make to themselves as a means of improving the relationship with their co-parenting partner. The other thing that we do in the initial joint session that's important, aside from confirming our understanding of all of the different things that we've discussed so far, is I work with them to develop what's called a co-parenting agreement that's going to be read to the children. And essentially it is, and we'll change the words and we'll put it into words that they know their children will understand, but essentially it conveys these thoughts. We're sorry that your life has been inconvenienced by our choice to get a divorce. The divorce is not your fault, it is our choice and our decision. And we're going to do our best to co-parent with you so that your interests are met. But there's a couple of things you need to know. Number one, you can't come to one of us and complain about the other. Because if that happens, what we're going to do is we're going to work with you to help you learn how to express that concern to the other, as opposed to just leaving it in my pocket or asking me to do it for you. The other thing is, it's kind of the converse, if you hear me complaining about your co-parent, please call me on it. I'm giving you permission. Name it, tell me that I'm not supposed to do it, and you even have permission to go tell your co-parent. That's how serious I am about wanting to be held accountable on this point. Finally, I ask the clients to address the concern that often happens. Well, I want to do this, and Dad said yes. What do you say? That sets up a really terrible dynamic. So I introduce them to the process of saying, well, thank you for expressing your concerns. Dad and I are going to talk about that, and we will get back to you with our decision. So this way here, the child knows I can't play one against the other, and God, let me tell you, they're going to do it. It's part of growing up, I think, particularly in a binuclear family. But it's a way to try and set the framework. Once we've worked out all of the language on this, By the way, and the last point is, and by the way, we're working with somebody, he's a parenting coordinator. If we're really at a disagreement and we can't agree on something, we promise you we're going to bring it to that person and have him work with us to find a solution. And guess what? Even if I personally disagree with the decision that gets made, I'm going to support it for your benefit. And this is all in writing, and it's one of the first things that the clients are asked to read to their children once the initial joint session has done and we've got our work rolling forward. I do my best, as I was talking about agendas, it's important to have the agenda and why the parent thinks that particular goal or result that they're looking for is in the children's best interest. And then, as I said, I work together to try and find a mediated solution and only arbitrate when it's absolutely necessary. In the process of resolving their conflict, I think it's important for us to set up a framework that allows the parents to use the tools that we've given them and to practice. One of the things I always do is I give my clients permission to fail for all I learn. And if they're willing to accept that and accept failure within themselves and perhaps tolerate failure by their co-parent, again, we'll start to see a shift in the relationship. So the process goes something like this. I have a concern. I will raise it with nonviolent communication. So, Joe, I notice that when the children come home, their backpack is always full of dirty clothes. That really makes me feel like you're not an equal in this co-parenting relationship, and you're not doing your piece according to our agreement. And I have a need for us to really work together. So I'm going to ask you, will you going forward please make sure that when they come home their clothes are clean? 4-step process, very simple. Sets up the issue. It allows the other parent to answer the question. If there is an acceptance or an agreement on that, then that agreement gets put into an agreements document that's posted in our Family Wizard. If there's not an agreement, they have 2 rounds within which to try and work out their problem. When they're working out the problem, I introduce them to the so what's your proposal model, which is essentially, I'm going to give you a proposal and you can ask me any question you want except for why. What if, how about, when, where, what's it going to look like? And I will then answer those questions. You then have the opportunity with that information and the original proposal to say, yes, I accept your proposal, no, I reject your proposal, or here is my counter proposal. They can go through that process twice on an issue. If they're unable to come to a solution with 2 rounds, please bring it to me. Because what's going to happen after that is the process will break down, they're going to get down the rabbit hole of blame, which brings defensiveness, which ultimately brings contempt, which ultimately brings stonewalling, and what got them into our office in the first place. I talked a little bit earlier about expenses. One of the things that I like about our Family Wizard is that it has a function where when there are shared expenses, be it for extracurricular activities or medical situations, the parent who expended the money has the opportunity to take a picture or scan a receipt and to post it in our Family Wizard in the expense section. My communication protocol says this: when you get the notification that there's been an expense posted, you've got 7 days to look at it. Within that 7 days, you can either accept or reject the proposed expense. If you reject it, then obviously it's going to come to me and we'll talk about it. If you either ignore it or accept it, then it's deemed a valid expense. You're going to pay your share, and you're going to do that either within 30 days of the date that the expense was posted, or the next time money is exchanged between you if there's a child support or alimony payments coming involved. I find that by using this process, it helps to not only alleviate a lot of conflict, but it also gives a clear central repository of all of the expenses, should God forbid they have to go to court and fight over them. So Yeah, so that's again one of the advantages of our Family Wizard is the expense function. The other thing that I like about our Family Wizard is in the calendar function, there is an opportunity to make a trade request. No need for a big long excuse, song and dance about what, I've got to go to this party with my significant other, blah, blah, blah. Will you trade this day for this day? X number of hours, it's either accepted or rejected. If it's not accepted, then I know it's my responsibility to find child care for the child for that particular event, or to know that the request has been rejected and I now have to adopt and adapt my plans. The other things that's very important for me to make sure that my clients understand is that I am involved in a consultation group, and that I value peer review. So I will be discussing aspects of your case without attribution, and in no way that you can be identified, but so that I can find the best solution and I can continue to learn from the situation. The other thing that's in the policy and guidelines is something that's inevitably going to happen. The client's going to be dissatisfied with me, some decision I made, whatever, think I'm biased. There's a whole process in there about what happens when there's a conflict with me or a disagreement with how I've done something. And essentially it goes like this. First, you bring it to me in writing. I respond. If we're unable to resolve it, and you feel as if this is a legitimate complaint that you need to bring somewhere else, the next step is we bring your attorney in and we see if we can resolve the conflict at that level. And if we cannot, then you must, before proceeding elsewhere, you want to go to the board and report me, you want to go to some licensing authority, you want to sue me. No. First you have to go back to the appointing court and the appointing judge and see if we can resolve the problem at that level. And again, it's very process oriented and designed to help resolve things in a way that is less costly and less challenging for everyone involved. As I said, I may have said this already, one of the other things that I have in my agreements is that I don't go to court. I'm not going to testify. So our Family Wizard, anything that's in there is admissible in court without objection. And I've yet to have that challenged. I don't see any reason why it would be. It's a contractual obligation that clients are free to accept or reject. So, but what do? Like I said, everybody's going to use our Family Wizard. So you got 5 days after the initial joint session to populate the calendar with all of the parenting time that your children will be sharing with you, and any extracurricular or medical appointments that you are primarily responsible for. Traditionally, what happens is clients will put in the extracurricular activities and the medical appointments. And I have to invariably write and say, I really need you to put in the parenting time. Why? We know what that is. Right. But I don't know what it is. Come the point where I have to make a decision where I might have to change the parenting time, I want to be able to know where does it fit in the schedule and how is the child going to be impacted if I were to decide one way or another. I talked about the expense function. It is invaluable. I had one couple that was the only function that they used for a year. And after we resolved some of the initial open concerns that they had. And they were very pleased to have done that. I'm clear that there's no texting except for emergencies. Everything's in our Family Wizard. If you do communicate outside of our Family Wizard, and I'm not oblivious to this, I know most parents do, but if it blows up and it becomes something that you want to bring to me, great. You put it in our Family Wizard, and I don't do texts. I don't do reverse order reading. My mind doesn't work that way. So please put it in chronological order so that it will appear when I have to look at it the same way it would as if it were a conversation in our Family Wizard. Because in our Family Wizard, when you start a communication, you give that thread a name, and it goes, like I said, back and forth 2 times. When it comes time for me to look at it, it's a self-contained process. Everything that I need is right there. If there's attachments, I know to go look in my files, and that's where the documents are posted. The other benefit of our Family Wizard is that I don't have to be CC'd on every correspondence. once I've been granted professional access, I get to see everything that happens. In fact, I can also see when parents log in, and the deal with me is if you log in, you are presumed to have read the most recent message. So don't tell me you didn't read it. Okay? But I get to see exactly how that works. And only when I am CC'd on a thread will I charge time to the file. So if you want to communicate with me and you want to have a private conversation that your co-parent you don't want to be part of, that's fine. Tony, I'd like to communicate with you about about the way that I'm going to express this message to John. Wonderful. Now John knows that we're speaking and what we're speaking about. I respond typically saying, great, let's have a call on Tuesday at 2 o'clock. And John, if you'd like to communicate on the subject, please let me know. We'll set up a call. It's pretty straightforward, but it gives everybody notice and an opportunity to be heard. You can feel the lawyer in me, can't you? When there's communication in our family wizard, one subject per thread, keep using the same title. One of the flaws in our family wizard is that you must respond to the most recent post in that thread. Otherwise, you get a split thread and it gets to be a little bit confusing. Like I said, 2 rounds. You can't work it out, you bring it to me. If you bring it to me, we have that agenda, we have that proposal, we have the rationale in advance, and that's the way we work. The other key item in my communication protocol is that there's a transition email. We've all had cases where you see the hassle at the Dunkin' Donuts or the school where parents are arguing, the kids in the car. That's not healthy. That has to stop. So how do we stop it? Anytime the child is transitioning from the parenting time they're spending with one parent to the parenting time they're going to spend with the other parent, the previously on-duty parent has a list of topics which we agree to in our initial joint section that they will address. It may be school, it may be social, it may be medical. And if there's something to report, you can cut and paste this into a Word document, type the information that you want your co-parent to receive, paste it into the transition email, and send it off. It goes off within 24 hours of the transition, and there's nothing else in that email except for transition information. And vice versa when the child is coming back the other way. It's I meet with a lot of resistance sometimes from parents. They don't want to. We're parallel parenting and there's no need. Great, let's narrow the subjects then. But these are the topics that joint custody requires you to know about and to agree upon. And we're not going to keep somebody in the dark just because you don't want to communicate. You will communicate. The final thing I'd like to say before I get to my thank yous is this. Probably the hardest thing for clients to understand is that as a parenting coordinator, we can guide, we can educate, we can teach, we can do a lot. We can make recommendations, we can make binding decisions. But where our power ends and what we cannot do is enforce our judgment, our decisions. It's only at that point that the client must resort to the court, either to say, I don't like the decision that Pelusi made, and they can go have that issue. They obviously have the right to go back to court and to litigate that. Or Pelusi made this ruling, and I'm quite frankly not going to do it. Now it's up to the other parent, if they believe that it is an appropriate subject with consultation with counsel, to bring that to court and have a judge make a decision. There was a case decided, I forget the name of the case, but Judge Abby Ross was the one who decided it. It was affirmed in the appeals court, I think it was 2018, that said a determination, a binding decision of a parenting coordinator is the functional equivalent of a court order, and it can serve as the basis for a contempt action. Again, that legal standards, it's got to be clear and convincing. There's got to be ability. It doesn't mean that there is going to be a contempt, but that's the force of the judgments that we issue. And it's important for the clients to know, I can do anything I can. I can talk, cajole, invite, but I cannot enforce. I cannot make a parent do what they choose not to do. So we've talked a lot about the do's. Let's talk a little bit about the don'ts, right? I kind of alluded to one early on. The first was make sure you get the releases signed up front. Don't let the clients dictate the process, because if that's going to happen, you're going to lose client control at that point, and it's going to come back to bite you, later on. The second don't rely on memory. I'm in the middle of a situation now where the dispute between the parents is whether or not in court it was said that mom would get a new therapist. Mom says it was never said. Dad says it was said. We can argue till the cows come home. My ruling was, when you, Dad, who assert that there was this statement made and want me to rely on that statement in deciding a matter, when you get a copy of the transcript and post it in our family wizard, we will resume the conversation. Because memories are fallible. So please make sure that you understand that. And as the professional, as challenging as it can be sometimes, when you end a call, you may want to go kick the dog. You may want to go out and take that walk in the woods for a while. But when you get back, get your notes, summarize them, and post them. I post them in our family wizard as my summary, and I put a note that says, you have 24 hours to review this. If you review it and have comments, please give it to me. If you have reviewed it and you don't have comments, it's deemed final and binding as written. So having the documentation is crucial. Don't hold so tightly to the process. So I mentioned the paradox at the beginning, where you have a process and you have flexibility. So I've outlined at great length the communication process that I've got. I have a meeting with my clients, and they say, we don't want conference calls. And this is probably a point that I should clarify. After the initial joint session, one of the things I ask clients to do is to give, before the initial joint session and after the initial individual session, I ask clients to prepare a list of individual concerns, open concerns that they have about the co-parenting relationship and the parenting of the child. And those are distributed to me in advance, and the other parent gets them because they're in our family wizard, so they see them. And then we have a meeting. And once we've confirmed the process, we start to address these open concerns. It's very rare that we've had a meeting where we've been able to, in the initial joint session, cover everything that I need to cover and resolve all of the open concerns. So my preference is, let's start off and have a conference call. We'll schedule a conference call for next week, and we'll, at that meeting we're in, identify which of the topics, in which order we're going to deal with the topics. And then we have the conference call. This particular couple decided, we don't want conference calls. We can handle it on our own. I said, okay, so you've got BIF, you've got so what's your proposal, and you've got nonviolent communication. Have at it. Process breaks down for a couple of reasons. First of all, they're not skilled in using the tools because they haven't been trained and exposed to them. And then parents decide there's too many emails going back and forth. So what do? Do we stop everything there? No. I gave you a shot. We tried to give you the opportunity to be flexible and to use this process. It didn't work. We experimented with it. So now we're going to go back to the original process, and we're going to set up a conference call. Dad says, no way. Of course, my first reaction, attorney, parenting coordinator, is, okay, dude, let me show you where the dog dies, and we're going to do it my way. And I stopped and I paused and I thought, and I had to remind myself, these clients, these folks that come to us, they're in pain. They're stuck in fear. They're injured. And they may be reacting, but they're not doing it necessarily with a malicious intent. So I thought about it, and I offered a third option. I've never done it before. We'll see if it happens. It's going to be shuttle diplomacy. So you don't want to talk during the business day. You don't want to respond. You want to respond once a week or once every other week. It's not going to happen. And I'm in the process now of trying to develop a protocol for what I'm calling shuttle diplomacy, where the issues will be presented, then it'll be a phone conversation. The summaries will have to get written. It'll get posted in our Family Wizard so the other parent knows, and then we'll go back and forth. So don't be totally inflexible and wedded to the process. Remember, the goal here is to help de-escalate conflict and get these folks to a better place, and be willing to play with your process along the way. So one of the questions that often comes up is, how do you charge? So my billing rate is set out in my service agreement. It's $350 an hour, and it is for all time, including preparation, which is essentially reading the separation agreements, any judgments of contempt, any guardian ad litem reports, anything of that nature. I have 2 very detailed questionnaires that I send out. One is basically it's a MASIC, it's a behavior assessment to assess for interpersonal violence, look for power and control imbalances that I have to be aware of in the process. And the other is a pretty detailed demographic questionnaire that I ask the clients to fill out. The questionnaires themselves are maybe 7 to 10 pages. Well, the longer one is 7 to 10 pages. The last one I got back was 40 pages. It took a lot of time. And it was 40 from one and 35 from the other. So you could kind of see the dynamic in this relationship. They use a lot of words, they talk. I know I use a lot of words, but I try and be lean of speech. But I charge, I read all of that material that gets read. I charge to the file. It's 50-50 or however the court has assessed the costs. When I'm monitoring communications where I'm not CC'd, I just kind of check in and say, okay, how are they doing? What's going on here? I may throw in a comment. Geez, that was an interesting point that you made. Do you think you could take a look at the BIF protocol again and see if there's a better way more effective way to communicate that? I'm not charging for that. I don't charge for the scheduling emails and all that stuff. But if I get CC'd, if I have to make a recommendation, yeah, I'm going to charge for it. This morning, before we did this taping, I had to post a couple of emails. One was a summary of our initial joint conference that I drafted on Saturday, and I charged for that time. I put it aside. I waited yesterday, this morning. I reread it and finalized it. I'll charge for that, and then I post it and share it. I try and be pretty transparent about the costs. My process is more front-end loaded, and I let them know up front, it's going to cost some money to get this thing set up. But if we spend the money at the beginning, and you understand the process, and you're willing to work with me to learn to make these changes, dramatically the cost will decrease as you become more skilled in your co-parenting relationship.